Hi Vikas. We are here to talk about COVID-19. As we know, it's the new discussion point in a lot of places right now, especially in the legal field. In this respect, I wanted to ask you, what may be the impact of COVID-19 for commercial contracts?
See, so far as contracts are concerned, most of the contracts do make provision for force majeure. And the courts have taken a view that you have to strictly go by what exactly has been defined in a particular contract to be a force majeure event. So first of all, parties concerned will have to see as to how the present event can be covered under a force majeure event as defined in the respective contracts. So that is the first thing that they have to see. Secondly, they have also to be aware and take care about how they have provided in their contract such an event should be dealt with. In most of the contract, there is a provision that once such an event or a force majeure event happens, one of the party puts the other party to notice, defining that this event has happened and this is going to impact us. And during this period, the respective obligations of the parties remain suspended. So, in the present scenario, I would say the parties need to look at their respective contracts and read them strictly so as to find out whether this event is covered under their contract, their force majeure event as defined in the contract, and act as per their own terms and conditions.
Now, what happens if the contract is signed?
Yes, that is another good point. If the contract is silent, then one has to, again, I go back to the legal scenario. The courts have said that a commercial difficulty per se is not an impossibility, because if the contract is silent, then the only provision we can fall back on is Section 56 of the Contract Act, which talks of supervening impossibility. But there are several judgments which say that mere commercial difficulty is not equivalent to an impossibility. So one has to see, because in today's scenario, though we can see some difficulties have arisen, but in all the situation it may not be impossible for the party to act. It may be only a commercial hardship. So they have to take care of this aspect, and once they feel that yes, they are not able to act, then they must again put the other party to notice, taking resort to Section 56 of the Contract Act.
And what happens if the contract is signed and the event extends beyond a reasonable period?
Again, that will depend on the facts and circumstances and the kind of contract that we are talking about. If suppose there are two scenarios, if suppose because of this event, the impact on one of the parties is such that it is completely ruined, so of course it is not in a position to perform its obligation even after the event is over. So that can be one situation, and that can give a valid justification to the party to come out of the contract. A second situation could be the subject matter of the contract. If the subject matter of the contract itself dies or becomes meaningless within this period, so there also the performance will be discharged by law or by the mutual consent of the parties.
Okay. So from what I understand from you is that now in these times parties must revisit their commercial contracts to understand and evaluate what the position at this point may be.
And act according to their contracts.
Yes. Thank you.